Well, thank you. Good morning and I guess good afternoon for some of you. I am Jacob Stein, and I'm an attorney. I practice in Los Angeles, and my practice focuses on asset protection planning and international taxation, but primarily asset protection planning. Over the 15 years I've been doing this, I've represented a little bit over 2,000 clients, from net worths ranging from a couple $100,000 to a couple billion. I've done it all, I've seen it all, and some of it I will be able to share with you today, given our time constraints. So this presentation is focusing on asset protection for business assets, and we'll try to focus on that today, but we'll touch on some other areas as well. And what I aim to do today is make this presentation as practical as possible, give you a lot of sort of real-life, real-world advice, and share some interesting client anecdotes and stories that will illustrate how all this stuff works in practice. So we'll certainly cover legal substance, but I do want to make this very practical for you. If you do have questions, either during the program or after the program, you are welcome to submit your questions. Now, the questions that you submit through Stafford, I will only answer those questions that are general in nature, meaning they relate to asset protection at large and not to specific client situations that you may have. So if you have a specific fact pattern you would like to run by me, you would need to email me directly, and then I will answer your questions. And my email, if you'd like to write it down, although I think it's in your materials, is Jacob, J-A-C-O-B, at lataxlawyers.com, lataxlawyers.com. Okay, so with that, let's get started. And the first question of the day, and I think a really important question, what is asset protection? I mean, the name of this discipline seems to suggest that it's exactly what it sounds like, asset protection. We are making assets unreachable by claims of creditors. And when you start practicing in this area, you find out that really the goal of asset protection planning is not to make assets unreachable. It's not really to protect them sort of in the traditional sense of that word, because most of the time, absolute protection is just not in the cards. There's just, when you hear the term bulletproof asset protection, there's just a marketing gimmick. Very rarely are we able to protect clients' assets in such a way so that they are not reachable by creditors. Although I'll give you a couple of examples where I think we can achieve bulletproof asset protection, or at least come very, very close to it. So if making assets unreachable is not in the cards, what is our goal? So let me give you one of my favorite client stories as an answer to that. My client is a doctor. He sits on the board of a nonprofit, and there are 4 other doctors on the board of this nonprofit. The nonprofit interviews a number of people for an executive position. They hire someone they believe is highly qualified, and one of the people that they interview but do not hire files a racial discrimination lawsuit. This racial discrimination lawsuit is filed against the nonprofit and each of the 5 directors, joint and several liability. And the doctor comes to me and says, this racial discrimination lawsuit, I'm really not worried about it at all. It's a completely frivolous lawsuit, but it sort of, opened my eyes to what may happen in life, the bad things we can come across. So before there is some serious claim against me, let me protect my assets. So we set up some of these wonderful magical structures that some of which we will cover today. And about a year goes by, and that frivolous lawsuit is concluded with a judgment for the plaintiff, $5 million. It's a real case, $5 million judgment for the plaintiffs. I guess maybe the lawsuit was not as frivolous as the doctor led me to believe. So the nonprofit has $1 million of insurance coverage, and now each of the doctors is personally liable for the remaining $4 million of this liability. Each of them had sufficient or nearly sufficient assets to pay off this liability. The plaintiff and their collection efforts go after 4 of the doctors. They do not try to collect against my client. Why is that? Well, if you remember this old joke, two guys are camping in the woods, a bear comes out. One of the guys sits down and starts putting on his running shoes. And the other guy goes, "Why are you putting on your running shoes? You can't possibly outrun the bear." And the other guy goes, "I don't need to outrun the bear. I just need to outrun you." This is exactly the same fact pattern. We did not need to make our client's assets unreachable. And given how late he was engaging in asset protection planning, that was not in the cards for us. But we made his assets more difficult and more expensive to get at than the other four co-defendants. Right? And the plaintiff is going to follow the path of least resistance. What is the easiest, most economical way of collecting on the judgment? Why fight my client and try to penetrate the structures we've set up when they can easily go after the assets of the other four defendants that have not been protected? Obviously, not in every single case will we have the other co-defendants that we can send the plaintiff after. But the logic does not change. If you can make it more difficult and more expensive for the plaintiff to come after the debtor's asset, you have changed the plaintiff's economic analysis of the case. And statistics that we have, and we've compiled these statistics from, as I said, about over 2,000 cases, tell us that in about 30% of cases, when the plaintiff is confronted with an asset protection structure, the creditor is confronted with an asset protection structure, they will simply walk away, meaning they will not try to somehow pierce these structures and reach the assets that we have been retained to protect. 30% of the time. Not that bad. Of the remaining 70%, vast majority of cases, something like 98, 99%, end up settling. And they're settling now on terms that are more favorable or a lot more favorable to our clients. 1 to 2% of cases, we are seeing plaintiffs and creditors try to sort of penetrate these structures we have set up, try to recover the transferred assets and get at them. So at a statistical level, anyone who engages in asset protection is doing something really good for themselves. But that is at the statistical level, right? For any one given client, there are so many random facts that play into this. We can never tell them you're protected, you're not protected, right? What are the random factors that play into this? And these are also actually the factors that we take into account, that we consider when we're trying to figure out what is the structure we are going to set up for the client. So think about this. In the world of asset protection, there are probably 24 commonly used structures. 24 commonly used structures to protect assets. So when a particular client comes into your office and says, I need to protect this asset, how do you know what you will do for him? There are so many different options. So what we do to make that decision, to help us make that decision, is go through the analysis that you see on the first slide. 4 sort of threshold issues that we examine to determine the various kind of random factors that will play into the asset protection and, what our choices would be. So let's go through them briefly because from a practical standpoint, these are really important to get. The first one looks at who's the debtor. And here what we're talking about, other than kind of this straightforward distinction between the debtor being a natural person versus a legal entity, single or married, different types of legal entities, we are looking at how risk-averse is our client. That to a very great extent influences what the client will do to protect his assets, right? You can imagine 2 different people in an identical situation. Let's say both of them have defaulted on personal guarantees. What are they going to do to protect their $1 million residence? Well, maybe one of the individuals is a doctor and he's very risk-averse by nature, and he's willing to do whatever it takes to protect that $1 million residence. And the other client is a real estate developer and he's a risk taker by nature, and he's not going to be willing to do as much. He's willing to take his chances possibly, right? So that means different structures are being set up for these people. So who's the debtor? Next question, what is the timing of the claim? Is there going to be a bankruptcy eventually filed for the client? Timing means, are we engaging in asset protection planning before something bad has happened to the client or after something bad has happened to the client? If you were to guess, what percentage of clients would you say come to us before something bad happens to them, meaning they're engaging in planning on a prospective basis? Well, the number is something around 10%. Only 10% of clients engage in asset protection planning before there is an acute need for it, which means that 90% come to us when there is a specific reason why they want to protect their assets. Something bad has already happened. They already defaulted on that personal guarantee. They already ran over a pedestrian. They already were sued for breach of contract or what have you. Why do you think that is? Why is it that so few people engage in asset protection planning ahead of time? I believe that the reason for that is human nature. As simple, or I guess as complex as that. It is human nature to believe that bad things happen to other people, right? Bad things never happen to us. I have my entire life's worth of experience to prove that. Bad things have never happened to me. I've never been sued before. I have never before lost all of my assets. Therefore, that will continue to happen to me, right? That is the thinking. That is the thinking, until that bad thing happens to you, and then you say, well, how is that possible? But by then, it's too late. So the vast majority of clients come to us after the fact, which means that the structures we are setting up now have to be a lot more robust, a lot more aggressive to withstand the possible fraudulent transfer attack. And we'll talk about fraudulent transfers in a few minutes. For clients who are engaging in asset protection planning on a prospective basis, they see the come, nothing is happening, there are no claims outstanding against them. They can set up very simple, very straightforward, very inexpensive structures, and they will work exceptionally well. They'll be very, very effective. Right? But the clients who act after the fact, the structures have to be a lot more complex. Bankruptcy plays into what we do also to a great extent. So, for example, a client's business is not doing well. He believes that the business may be shutting its doors in a few months, but the business, today has some assets still, still some significant assets, and the client would like to see what he can do to protect and keep those assets. Well, if the client knows that at some point in time he will be filing for bankruptcy, right? Maybe not today, maybe let's say in a year's time, we need to be really careful of that. Why? Well, for two reasons. First of all, if the client pays you legal fees, and then the entity that paid you the legal fees within a year files for bankruptcy, the bankruptcy trustee may be able to get the money back as a preference payment, and you lose your legal fee even though you did all the work you were hired to do. So we need to be careful in situations like that. Who is retaining us? Maybe if the business entity will be filing for bankruptcy, we have the individual behind the entity retain us and pay us our fees. The other reason that bankruptcy is important is that outside of bankruptcy, asset protection structures, let's say, may work really well, but once in bankruptcy, maybe not so well, right? Because once you're in bankruptcy, what will happen? Well, now you have a bankruptcy trustee who is examining everything that was done to protect assets, and bankruptcy trustees are fairly knowledgeable of debt collection laws. They're very knowledgeable of fraudulent transfer laws, and they tend to be fairly aggressive as far as creditors go, right? So we have an aggressive, intelligent creditor pursuing us. The odds of that structure working decreases with a creditor like that. If the judge doesn't like what the client did with his asset protection, the judge may simply deny the bankruptcy discharge. So bankruptcy on the horizon, we need to be exceptionally careful as to what we are going to do for the client. And understand that clients who seek bankruptcy help and asset protection help are pretty much one and the same client, right? It's people in very, very similar circumstances. You owe money to someone, you are not able or do not want to pay that money, you seek help. So how do we know when someone should go to a bankruptcy attorney versus an asset protection attorney? Well, I think the distinction is a straightforward one. Someone who has no assets goes into bankruptcy because there would be nothing for me to protect. Someone who has assets cannot go into bankruptcy because they will lose the assets to the bankruptcy estate. So they could come to someone like me to protect their assets. Okay, the next factor is the identity of the creditor. Here we are looking at how aggressively the creditor will be pursuing our client, how intelligent is this creditor when it comes to asset protection and debt collection laws. And, you know, this is something that you sort of learn from experience. So, for example, we've represented, since 2008, we've represented something like 300 real estate developers and investors being pursued by banks on personal guarantee claims or different types of lenders and personal guarantee claims. So experience has shown us which lenders are aggressive in their collection efforts, which lenders are not so aggressive. We represent a lot of clients when they're being pursued by federal and state agencies. So we know which agencies will pursue our client aggressively, which will not. I'll give you an example. I have a client that owes U.S. Customs over $10 million on unpaid custom duties. And Customs is very aggressively pursuing litigation against the client, and they will probably get a judgment against the client, a very significant, very large judgment. Once Customs gets that judgment, what do you think they will do with that judgment? Well, it turns out that they very likely will do pretty much nothing with this judgment. It's not in the, you know, it's a large bureaucracy, U.S. Customs, like most federal and state agencies. It's a large bureaucracy. There's no bureaucrat at that agency who's going to get a commission for collecting on the judgment. So once they get the judgment, you know, it looks good on their service record. They've done their job, and then they move on to their next case. So last time I looked at this, U.S. Customs had, you know, over $2 billion in uncollected custom duties and anti-dumping penalties and things like that. So you need to know your creditor. Even someone who is commonly perceived as like this, you know, the big bad wolf of creditors, the Internal Revenue Service, in reality is usually not that bad if you know what to do. Because the person collecting on their behalf is a collections officer who follows the guidelines set out in the Internal Revenue Manual. So if you know what the Internal Revenue Manual tells them to do, what steps they will follow to collect on a tax assessment, you may be able to get around them being able to collect, right? So you have to know the other side. And the final factor, and this is probably the most important one, are the nature of the assets we are protecting, meaning what are the specific assets that the client has that we would need to protect. Does he have a personal residence? Is there equity in the personal residence? Does the business have inventory? What sort of inventory is it? How is it owned? Is it on consignment? Does the business have accounts receivable? Can accounts receivable be factored, or can we place a UCC-1 filing against the accounts receivable? Are there bank accounts and investment accounts? Is there intellectual property? Are there interests in a professional practice? Rental real estate? Right? So all these different categories of assets will usually call for different types of asset protection structures. Some assets under state law will be exempt from creditor claims. Now, this doesn't apply to business debtors, meaning a business entity is not going to get an exemption as a general rule to the same extent that a personal debtor would. But even when a business entity is being sued, there is one exemption that may apply, and that's exemption for retirement plans. And the way it would work vis-a-vis the business entity is that if there is, let's say, a pension plan or any sort of a retirement plan that this entity has, the entity does not own the plan. The entity is simply the sponsor of the plan, right? And the plan is actually technically a trust, and there's a plan administrator that's acting as the trustee of the trust, and the employees are the plan participants and the beneficiaries of the trust. So your client's business entity is not the owner of the plan, so the assets of the plan are not reachable by the creditors of that entity. So this is sort of the initial look at what we are going to do to try to figure out what we're going to do to protect assets. Now, let's start getting into some specific obstacles and some specific planning strategies. So we are going to move on to the fraudulent transfer slide. The law of fraudulent transfers is the big obstacle in asset protection planning. Without this, you can do anything you want to and everything works. What do I mean by that? Here's the basic legal principle that asset protection planning is relying upon. And then this is, I think, really important to get. If you own an asset, then anyone suing you, any creditor that you have, would be able to get that asset, with the exception of, assets that have been specifically exempted under state or under bankruptcy law. Right, so if you own a nice shirt and you get sued, can the creditor take the shirt off your back? Well, some amount of clothing would be exempt from creditor claims, but maybe not all of it, right? So if your spouse has a very nice shoe collection worth thousands of dollars, maybe some large part of that shoe collection is actually attachable by a creditor. Has that ever happened? Has anyone ever done that? I don't know. I've never experienced that, but technically it's possible. So pretty much any and every asset, unless it's exempt, is reachable by creditors, which, if you think about it, is very scary. I will tell you that probably the biggest misconception that our clients have when they come to us is that they believe that their home is sacred. Not sacred just to them, sacred to the world at large, that no one will be able to reach their home. And they're very surprised to find out that that is not the case, that in the vast majority of states, your home, your residence, is reachable by claims of creditors. But other than these exemptions, which we'll discuss maybe later if there is time, everything you have is reachable by creditors. Now, the flip side of this coin is that if there is an asset that you do not own, like it ain't yours, your creditors cannot take that asset from you. Which seems like kind of simplistic, right? Well, of course, if it's someone else's asset, how it can be taken from me? Well, but that's really what asset protection planning is all about. If you own an asset, the creditor can take it from you, and if you do not own an asset, they cannot take it from you. What asset protection aims to do, every single asset protection structure aims to do that, is to take an asset that our client owns and make it into an asset that our client does not own. That's exactly it. Every single asset protection structure, from the simplest to the most complex, aims to do just that. Take an asset that the client owns and make it into an asset that the client does not own. That's easy to do, guys. Take all of your assets and donate them to the Salvation Army, and you will no longer own them. Anyone wants to do that? Probably not. So there's a bit more to it than simply making the assets not yours. We want to make the assets not ours, but we want to do it in such a way so that we retain control over the asset. We want to do it in such a way that we retain the ability to make the assets ours tomorrow, should we choose to, right? And we want to be able to engage in all of these transfers of assets without any tax consequences. That's really what we aim to do. That's what asset protection planning is all about. So with that in mind, if I own an asset, it can be taken from me, and if I do not own an asset, it cannot be taken from me. Well, what does that imply? It implies that if I get sued and I'm afraid of losing my home, let's say, I will simply transfer the ownership of my home to a family member. And every single client, right, that we come across, that's the first suggestion that they make. Right? Can I transfer my assets, let's say, to my kids? Easy thing to do. Kids are, sort of the natural choice. They're the natural objects of your bounty. So can we simply transfer assets to family members? Well, if debtors were allowed to do that, no creditor would ever collect on the judgment. And the body of law that prevents debtors from engaging in these sort of last-minute transfers are the fraudulent transfer laws. There are two types of fraudulent transfers. There is a transfer involving actual intent to somehow make your creditor worse off, and there is a transfer involving constructive fraud. We'll get into those in a second, but first, before we can have one of these two types of fraudulent transfers, we need something that qualifies as a transfer. Well, the word transfer seems like a very simple word. I mean, we use that word on a daily basis. And if I get sued and I transfer the ownership of my home to a family member, that's a transfer. Yes, that is. But the definition of the word transfer for the purposes of this test is much, much broader than that. For these purposes, the word transfer is defined as anything that the debtor does that somehow makes his assets less attractive to a creditor. So, for example, let's say that I get sued and I have an apartment building that's in a limited liability company, right? I own the apartment building through an LLC. And I say to myself, well, I can't transfer the ownership of the building. It's too late for that. But maybe I can change the terms of the operating agreement of the LLC. And that's all I do. I just change the terms of the operating agreement. Well, guess what? If changing the terms of the operating agreement made the creditor's job more difficult, that action of amending the LLC agreement becomes a transfer. And once we have the transfer, now we test to see if it falls into one of these two categories. So it's okay to have a transfer. Just because we have a transfer doesn't mean it's a fraudulent transfer. We have to test for that separately. But first, we need to see if there is a transfer, and it's a super, super broad definition of the word transfer. So any action that the debtor takes that makes it more difficult for a creditor to collect would be a transfer. So the first type of a fraudulent transfer, and this is the one you hear about most frequently, although in practice it is not that often used because it's much more difficult to establish, is a transfer involving actual intent to hinder, delay, or defraud any creditor. Actual intent, what does that mean? I highlighted those words on the slide. Actual intent means that the creditor must prove that when I transferred my home to a family member, the purpose behind the transfer, my intent behind the transfer, was to hinder, delay, or defraud their collection efforts. Well, how can they possibly know what my intention is? Any thoughts? My intention is somewhere deep in the recesses of my mind. How can the plaintiff, first of all, know what that is? And second, how can they prove that in a court of law by a preponderance of evidence? Well, you cannot actually prove someone's intention directly. It's impossible unless the debtor signs a declaration saying, I intended to screw my creditors. So what we do is we infer intention. We infer intention. How do we infer intention? Well, we infer intention based on circumstantial evidence. We look at the circumstances surrounding the transfer, and we infer intention. Given the fact that the transfer took place after a lawsuit was filed against you, well, maybe that implies what your intent was. Maybe because you transferred assets to a family member or to an entity that you control, that implies intent. Transfers for less than fair market value, transfers at a time when the debtor is insolvent, transfers that you try to hide, right? So all these different types of transfers, all these different indicia of intent can result in a finding of actual intent and therefore a fraudulent transfer. So from state to state,